Hi, everyone, and welcome back to Commerce Meets Law, a podcast we talk about various commercial topics and how they interact with the legal profession. Last week, we began a very exciting series on the podcast with three leading barristers in their respective areas of the law. And last week, we had Mani Singh Bassi on the podcast. He's a family law barrister at 4PB, and it was a fantastic conversation. So I definitely urge you to check it out if you haven't done so already. For today's episode, on part two of the series, we have a guest that I feel so honored to have on the podcast. Our guest today is Tom Cross, a leading barrister at 11 KBW, practicing in public, human rights, education, media, and sports law. Tom is also the creator and host of the Cross Examination podcast, which is aimed at law people, lay people, and everyone in between. Just like that slogan, Tom's podcast is brilliant and I urge you to check it out. So I'll leave the link down below and also leave a link down to his website. As a way of background, Tom was the Legal 500's Public Law Junior Barrister of the Year 2018 and Chambers and Partners Employment Law Junior Barrister of the Year 2019. In 2022, he was nominated UK Public Law Junior Barrister of the Year by the Legal 500 and was nominated once more in 2023. Some of his more recent cases include Lucy Letby's judicial review of her legal aid, the court challenge to the COVID lockdown, advising on the Partygate inquiry, and the challenge to the parole board's decision to release the black cab rapist, which is something we discussed during the episode. In the first part of our conversation, we talk about Tom's journey from studying modern languages at the University of Oxford to gaining a pupillage at Francis Taylor Building, and the journey is an inspirational one, articulated, I'd say, rather modestly by Tom, which is a fascinating listen. In the second part, we discuss Tom's reasons for moving to 11 KBW, where he's been since 2010, and also what his current practice involves. Tom regularly represents clients in extremely high-profile cases, which do garner a lot of media attention. So we also dive into the approach that Tom takes to such cases and try and bust some myths around the profession of a barrister, which I hope that you find interesting and insightful. The final part of our discussion centers around Tom's motivation to start the podcast and what his aims are with the matters he chooses to discuss and the guests he chooses to bring on. As a fellow podcaster, obviously I found this super interesting, but I think above that, for everyone else who's listening to this conversation, Tom highlighted the importance of ensuring that he had a range of views when he presented these seemingly contentious topics, which is a message that many of us need to remember in a world that can seem increasingly one-sided based on the echo chambers that we choose to operate in on social media. I think it's really easy sometimes to forget perspective and to forget that there are always two sides to an argument. And that's what Tom tries to bring on this podcast, which I think is super important and something that, we need to remember whenever we are looking at a news story or we're reading about a particular case. Now, without further ado, I hope you enjoyed the conversation and I'll see you right at the end.
Hi, Tom, and welcome to Commerce Meets Law. Super excited to have you on today and for us to kick off this series where we're going to be having a couple of barristers on the podcast. So we always have a bit of an icebreaker tradition that we sort of start off with. So in your opinion, what is your superpower?
Well, hi Shreya, and thank you for having me on. It's a pleasure. I mean, my superpower, if I'm answering the question straight, and I guess I must answer the question straight, it's been said that I suppose I'm quite good at concentrating. Remember my dad saying to me once that I have decent powers of concentration. He used to say it when I played sport. I could concentrate on hockey or I could bat in cricket, which I used to do without scoring many runs for a long period of time. And he thought that that was a useful skill to translate into what I ended up doing at the bar, because barristers, I think, like other lawyers, have to sometimes get their head down, don't they, and concentrate on documents and thinking about something quite intensely for a long period of time. So my straight answer to that would be that powers of concentration, I think, are quite good. And my silly answer would be sticking my ear in itself or something like that. But I won't attempt that even on a video-based podcast.
Definitely, and I think it's a key one, like you said, particularly I think as a barrister when you are focusing on one case or one particular client for quite a lot of time, and it's probably one that is hard in today's digital age where we have so many distractions around us. So concentration is definitely a key skill. And we always start by exploring a bit of the academic background of our guests before talking
Yeah.
a bit about the professional side. So I wanted to start for you at the point of when you went to university. Could you speak to us a bit about why you decided to study modern languages and what you were kind of thinking about at the time in terms of career aspirations?
Yeah, I did French and Spanish at Oxford University. I had really liked doing French and Spanish for A level. I did for A level, I did, gosh, what did I do? It's a long time ago now. I did French, Spanish, Latin, and English literature. So not a scientist. And that must say something about the fact that I quite like words. I'm quite comfortable with words. I was quite good at making argument using words. I was quite good at things like literary criticism, and I enjoyed reading. And French and Spanish I liked. I liked the process of learning language. At Oxford, the modern languages degree was also very literary based. So it enabled me to, and it turned out to be exactly the right thing for me, actually. I really enjoyed it, the learning of the language, but also developing arguments, critical thinking, writing essays about works of literature, which happened to be in French and Spanish, although just occasionally you'd read the translation to give the secret away. But so it was something that I thought I'd enjoy and luckily did end up enjoying. I quite often say to people who ask, should I do law as an undergraduate degree, who are at that point thinking about rather a long way off in the future doing law as a profession. And I have to say, informed, I'm sure, by the experience that I had, I always give the same answer, which is do what you think you'll most enjoy. My view is don't do law just because you think it might advantage you, which I'm not sure it necessarily does, by the way, to have a longer undergraduate degree in law if you're then going to go into the legal profession. I'm not sure it does disadvantage people to have that, as long as they get through their, they get a good degree and they get the legal part of the qualification in the end. I think it's more important to do something you're more likely to enjoy. And I think I probably did enjoy modern languages more than I would have enjoyed a full law degree.
Definitely. And I think that it is pretty 50-50 in terms of profession with law and
Mm.
non-law students. And increasingly, there are so many different pathways to coming into law. And I think that, whether you study a STEM degree or you study languages, I think you can really bring those skills and those transferable skills into the profession. Now,
Yeah.
when did you sort of first develop an interest in law and consider it to be a potential after university?
Well, it was probably during my year abroad during university, actually. So I did it. So it was a 4 year degree, like a lot of modern languages degrees are, with the third year being abroad, which I spent in Madrid in unbelievably 20 years ago, unbelievably to me, 20 years ago now, 2003 to four. And I guess it gave me loads of time to reflect on what I was likely to do afterwards in a way that you didn't have in the quite intense periods when I was studying at university, even though there were long holidays. And so it made me think, what really am I going to do the year after next? Um, there was some law in the family. So we haven't had barristers in the family, but my dad was and still is a solicitor. He did for most of his career, he's done employment law, he's done some areas as well. So we had some in the family, and through that, I had some level of knowledge of law. And I think I thought, partly for that reason as well, that my dad was a solicitor, I quite fancied the idea of doing something that was a little bit different from what he'd done. And there must be something in our genes because I'm one of three children. I'm the eldest, and I'm a barrister. The middle one is a drama teacher, and my younger sister is, or has been for most of her career, an actor. So there must be something performance related in the gene. So I reckon it was a combination of the interest in words and the wordy stuff and the interest in language that I was talking about earlier, combined with the fact that we knew a little bit sort of law in the family, but not barrister in order to do something different, combined with thirdly the desire to kind of perform, which I think, which is right. We do perform as barristers. We perform a bit less than people sometimes think. It's a bit less of a part of our job than people sometimes think, particularly if we don't do criminal law. I think it was probably a perfect storm of those things, really.
Yeah, and I think that's really interesting of, having that and seeing your dad, being a solicitor and having that experience, but then also realizing where your strengths are, where your interests are, and kind of combining. And I think
Yeah.
that whether you're doing law or not, you're not doing it and you're considering the legal profession, that solicitor versus barrister is a point that a lot of people do come to. So in order to, I guess, realized that you did want to go down the barrister route, did you have any work experience in those areas, or did you sort of target most of your work experience towards wanting to go to the bar?
I think probably the latter. I did, and
Mm.
I tried a few. I mean, very much like the solicitor's profession, the bar is very varied. And there is, a substantial difference between the day-to-day life of a criminal barrister, for example, from the day-to-day life of most sort of areas of civil law. So I did some work experience. So I'm from the northwest of England, believe it or not. A lot of people don't detect that from my accent, but I can put it on when I go back up there. I'm not quite a Scouser. I'm from the Wirral near Birkenhead, the other side of the River Mersey. But I, as a result of that, did some work experience up there on the Northern Circuit, Liverpool Crown Court, Preston Crown Court. Of course, the bar up there is much more general, rather than being divided into more specialist areas. So I make that as a generalization, but in the bar in London, the London-based bar is bigger, first of all, than any of the bars as centered elsewhere in the country. And so by doing a bit of work experience up there, I covered sort of general crime, did a few days general crime, saw some jury trials, things like that, saw some conferences with defendants in the cells, but also saw a little bit of family law that I didn't much fancy, I have to say, and a little bit of general kind of common law, so personal injury. I remember seeing a day in I think a county court case about a car accident. So I got some sort of general feel of things through that, and was very glad I did. And I always say to people as well on the issue of work experience, get as wide a range of experience as you can. Don't think, well, I probably won't like an area, so I'm not going to spend any time, because the process of eliminating things, I think, is just as important as trying to work out, here's positively what I specifically want to do. It doesn't always work out like that. I think it's all good. All experience is good experience in that sense.
Yeah, definitely. And I think, like you rightly said, that understanding where your interests lie and also understanding that, what you can sort of eliminate, because there are just so many different areas. I think particularly with barristers, people have the perception that it's just criminal law, but it is,
Mm.
it's so wide ranging, just like the solicitor profession is. And I wanted to talk a little bit about your pupillage. So could you talk to us about the journey to getting pupillage at FTB and sort of how that process occurred?
Yeah, so because I did a non-law degree, I had to do the law conversion course, which I did at City University in London. That was and is an excellent course. It's an intense course again because it's condensed down into 1 year, the academic part of it. And during that year, the timings were such that during that year, if you wanted to apply for pupillage, you could, even though you
Mm.
then have to do the vocational year, what was then called the BVC after. Um, and I did that because I felt ready. I felt sure at that stage I wanted to be a barrister and to go for pupillage as soon as possible. I had only been studying law for about 4 months at the time that round of applications were made. So there you were applying for pupillage is really very kind of early in your legal journey. But I knew that I didn't know much else about it, to be honest, but I knew enough about public law, and public and human rights law, which is what I, to this day, really focus on doing from studying it a bit, administrative law, constitutional law, that I was factually interested in it and therefore factually interested in applying to chambers that did it. And FTB are an excellent public law chambers. Their focus is particularly historically has been on planning and environmental law. And they recruited prior to the technical part of the answer to your question is that they recruited prior to the centralized application system that there is for barristers, which survives to this day. I think you can put down, it used to be 12, I think you now put down as many as 20 chambers, and they're centrally processed. So there are common questions in the applications that you make to all of these different chambers that the process then sends your application on to. But I was recruited by FTB, who were one of the smaller clutch of chambers who recruited prior to that system. They made me an offer. I had to decide whether to accept or not. I decided to accept. That meant I never actually went into the centralized system. But they were chambers who, unlike some of the others that were more focused on probably purely commercial law, who did that, they were one of the few that did public law, and I was interested in that. And so that's how I ended up there.
And I guess just on that point, one thing that I guess a lot of people do fear about going into the bar is that idea that, the solicitor profession is competitive, but the bar is equally, if not more competitive. And it can take a number of years in order to get that pupillage. So, of course, you sort of landed that quite a bit early on in your journey. But what advice would you have to someone who is considering applying and maybe knows the area they want to go into, but is not very sure of their chances, and how can they ensure that they can, kind of have the most success?
The first and most important thing is go for it. You've got to reach for the stars.
Mm.
And the stars, by the way, might be different types, will be different types of stars for different people. You may be thoroughly disinterested for a very good reason in coming to the bar. Any other type of any field within the bar, the solicitor route might be the one for you. There are also other avenues, by the way, that aren't, as it were, traditional solicitor or traditional barrister that are always worth thinking about. The laws are very, very varied, much more varied than even lawyers sometimes remember it as being or think of it as being. But you've got to get. You can't die wandering. You've got to go for it. And of course, I was very lucky because I got a pupillage straight away, and have been able, in the way that my career has developed since then, to move and slightly. I'm probably going to come onto this, but actually to move away from the area that I initially practiced in towards something I wanted to do more. So I've been lucky, and I appreciate it's easy, perhaps, therefore, for somebody like me to say this. But the general approach, I think, has to be, don't die wandering. You've got to give it a go. And if you're in a position, fortunately, to be able to give it a go and maybe not get something first time, doesn't mean you need to give up. Life's a long enough time that you will move in. Unexpected things will happen in life as well that will throw you off course. You can't control it all, so you might as well try and control as much of it as you can, where it's
Absolutely.
within your gift.
For sure. And coming back to talking a little bit about FTB and sort of what you specialize in, could you tell us what planning and environmental law actually is and sort of what it entails as a barrister? What kind of, things would you be dealing with? What cases would you be looking at?
As a barrister, and certainly at the chambers where I started FTB, the mainstay, the bread and butter work was in planning inquiries.
Mm.
Planning inquiries used to be longer than they are. The government has constantly tinkered with the planning system. There was a period in planning law, a bit before my time really, when we think of things like Manchester Airport expansion inquiry, barristers would be on public inquiries like that for in excess of a year, just on the issue of whether or not there should be an additional runway, albeit with all the associated paraphernalia that came with that. So planning inquiries work used to be very, very long lasting and enabled barristers to stay on a small number or single number of inquiries at a time. Over time, that slightly changed because inquiries have been shortened. There are more inquiries that are now done actually on paper, and those inquiries that are done in person tend to be shorter than they were. But that's the basic bread and butter. And then on the side of that, so the typical issue is whether or not X or Y development should get planning permission. That's the issue. There is a planning inspector who will decide that, who is unlikely to be legally qualified, but will usually have some sort of qualification in the area of town and country planning, and perhaps architecture, something allied like that. The other main bit of planning and environmental law would be, though, the court work. A planning inquiry doesn't feel much like it isn't court and doesn't feel much like court. There isn't, as I've just said, a legal judge there. There's an inspector who's a rather different beast, as it were. And it is a forum which is designed for members of the public to come in, listen, and indeed contribute. So it is a public inquiry in the true sense. The other bit of work on the side of that is, however, court work and things like judicial or statutory, similar to judicial reviews, statutory reviews of certain types of decisions. For example, if somebody wants to challenge the grant rather than the refusal of planning permission, then you challenge a grant of planning permission by judicially reviewing the body, for example, the local planning authority that's decided to make that grant. So there would be that side of it as well. And barristers who practice in the area vary in the extent to which really they just do the planning inquiries, or they just do the court stuff, or do a bit of both.
Okay, and I think that really gives people a sense because I think especially if you're a non-law student, or you're someone who has done law but hasn't taken that module, you sort of may not have that knowledge of, what that area looks like. And I think, once you get into practice, you're kind of learning on the job and you're learning about all these terms as you go along. For you, whilst doing it kind of during your pupillage, which of the areas at FTB did you enjoy working in the most, and what do you decide to qualify or specialize into once you finish your pupillage?
Well, I like the court stuff the most, to go back to that
Hmm.
distinction. I didn't mind the planning inquiries, but I got less enjoyment from them. For me, they felt that they could sometimes be a bit long. They felt that they could sometimes be on issues that weren't really legal issues or even issues that were necessarily capable of being resolved by competing evidence, whether or not a building's well designed, for example, whether or not it fits into its urban or rural context, is something that factually interests some people more than it did me, but in any event isn't something that really can be forensically dissected in the way that some other issues can be, many of which are absolutely canvassed in public inquiries. So I was less into the public inquiry as a forum and more interested in things like statutory or judicial review, where you'd go along to court where the judge was a legally qualified person, where there would be law, so issues of what the law was, as well as rather than there being a situation where there was really no dispute about what the law was, and it was just a question of an inspector taking a view on a set of issues in relation to a development or applying policies. Um, and you could also have a higher turnover of number of cases, which is something I quite like in my practice. I hesitate to say I get bored, but I don't like to spend a long time on one case. I quite like a practice where you have one thing, hopefully it's interesting, and then you can move on to the next thing. I'm
Hmm.
quite eager to get on to the next thing. So the court stuff appealed to me and does appeal to me, continues to appeal to me more than any other time. And I quite like the process of liaising, of engaging with the judge as well. And I enjoyed witness. The other thing to say about that is witness handling. Public inquiries were very heavily, you were very heavily involved in witness handling in those, as you are in many court procedures. I enjoyed witness handling, but I think I enjoy more the process of engaging with the judge. I quite like having a debate about a point of law and how facts would apply to law. And you get that kind of par excellence in judicial review and statutory review. And, you know, as I say, you can get through and encounter a range of quite interesting issues quite quickly.
I think that brings us nicely to talking about your move to 11 kbw, where you currently are now. So, could you talk to us about why you decided to move from FTB at that point and what you were seeking to gain when you moved to the new chambers that you're at now?
It does flow on, but I mean it's similar really to what I mean that what I've just been saying is the core of the answer to that really.
Mm,
I enjoyed the planning inquiries, but I enjoyed the court stuff more. So there was
mm,
an issue of forum there, and the balance of work that you're likely to have as a plan, essentially as a planning practitioner, is likely to be less court focused. But also factually, and I do say this to people a lot when they ask, what area of law should I go into? What area of law is going to appeal to me? But factually, planning for me, some people are fascinated by planning. Factually, it's interesting, but not as interesting, certainly as a sole specialism, as other areas are. And one of the features of the practice that I've been able to develop at 11 kbw is a practice where, as I say, you're not just on one case all the time. You have a number of cases on your desk at the same time, but they're also almost always on different factual areas. And so, if I just think of the last 4 or 5 most recent cases that I've done, one was on whether or not a school should be able to ban prayer. Another was on whether or not you should be able to do assessments before people are detained under the Mental Health Act, so sectioned in hospitals, whether or not you can do that remotely. So that's all about technology and remote versus in-person interactions. I've done cases in the field of social care, community care. Should somebody got the right care package in relation to immigration? Should somebody be able legitimately to claim asylum. In relation to business interests, I've recently done a case for a heritage train company who were being criticised by the regulator for having a locking system they were saying should be changed. These are all very factually varied areas, applying similar legal principles to a wide-ranging kind of set of circumstances. And I like that. I like a new, it enables you to travel into new areas of life that you don't do if, as it were, you do the same case time and again. So that was that difference in the emphasis in types of work that we do was the main core really of my reason for moving from FTB to 11 kbw.
Definitely. And I think understanding that is so important because, there isn't a right or wrong. Some people do enjoy kind of, doing that sort of not the same thing necessarily, but the sort of same process and, want to get really good at it. Whereas some, prefer applying that to various different, like you said, factual scenarios. And one of the things that is, really popular amongst a lot of social media sites is looking at the day in the life of a lot of people and what that looks like. So could you tell us what a day in the life of yours looks like on a day when perhaps you're on a case versus on a day when you sort of just come off one and are sort of waiting for the next one to begin?
Well, that's kind of it. It really is the case. I want to say no 2 days are the same. I know that's cliche, but it is true. I love that about the job, that you really don't have a day in the life that repeats. I mean, court-wise, what would be a typical court day for me? If it's over the road from where I am at the moment, I'm sitting in my room in Chambers at the moment in Temple, so I go over the road to the Royal Courts of Justice, and a judicial review might be a typical case for me. So I get my kit on. Over the road I go, lug over the stuff, or less stuff now if it's an electronic hearing, and have an argument in front of a judge, have a sandwich from Pret or other retailers are available during the lunch hour, come back, usually work on it overnight, sometimes rather late if it's a multi-day hearing. That's the intense part of the job. And, that's a typical kind of court case, whether I'm acting for a claimant or a defendant. If I'm not in court, I'm either preparing the sort of case that I've just described. And there's much more to that than people sometimes think. There are a lot of steps in a typical judicial review case that occur, particularly in the month or so leading up to the hearing. I've got a case in Manchester as we speak today in a couple of weeks' time, and I've spent a lot of the last week preparing the skeleton argument for it. But I mean, it's been about 3 or 4 full days, I would say, to do that skeleton argument. And though it doesn't show up in the diary, very obviously, it's very much something you have to budget for, if you like, in terms of your time. Another major thing, though, that I do is advisory work, and a lot of the public law bar will be advising, whether it's people who would challenge public authorities on where they stand, or whether it's advising public authorities on usually their powers and duties, the range of decisions, including policy decisions that they can make on some given topic. That's generally speaking what we advise on in public and human rights law. So that would be, writing an opinion, getting to grips with some papers, writing an opinion on that sort of case, which could be on any, as I said before, really any factual area that one could have government policy on, would be typical as well. As I've got older, as I've got a bit more senior, I've also tried to balance all of that stuff with doing other things like my podcast and things like that.
Yes, which we're definitely going to get onto later on and talking a bit about that as well. Just on the point of coming back to, you mentioned earlier of when you are doing judicial review cases, a lot of it is kind of speaking to the judge and then interacting with the judge in that sense. Someone who is also legally qualified and has
Yeah.
potentially been in the place that you have before becoming a judge. When you are, kind of dealing with judicial intervention or you are preparing those skeleton arguments, how prepared are you the day before, and how much of it is sort of spontaneous in the sense of kind of thinking about what the judge might be asking you on that particular day?
In theory, you're very well prepared. You should certainly be aiming to be very well prepared. It really is, what's the expression? 90% perspiration, 10% inspiration. It should really be pretty well 99%, having tried to think through not just what you're positively saying, but also thinking about the way that your opponent is likely to put it and the sort of questions that the judges might ask in advance. It really is that is the key to perhaps the golden rule, perhaps, of successful advocacy is preparation. And it isn't true that the barrister won't give that a good barrister who's doing their job probably won't give forethought to an issue and then will magically and brilliantly, inspirationally think of something on their feet and answer them. That might happen, but I'm not sure it's to be credited to the barrister if they have, because they probably, unless something is truly unforeseeable, they ought really to have been thinking about much of it in advance. Of course, you can't foresee, having said all of that, everything that might happen. Far from it at a hearing. There's always something that happens at a hearing that you couldn't actually fully have foreseen. But the job is very, very much to not just do that skeleton argument that'll be the positive articulation of your case and to stick within the four corners of that, but beyond that, to anticipate how you think likely the thing is to go in front of the judge. And experience, of course, does help with that. As a lawyer, I think true solicitor or barrister experience is, very, very valuable thing.
Definitely. And just on one of the other, I guess, misconceptions or perhaps a myth that people have of, how you're seen in court with your opponent is how you feel when you are outside the court. So can you talk to us a bit about the relationship you have with opponent's counsel, and is there that sort of interaction before you do step into the court and kind of, start your job in that sense?
Yeah, it's a very good question, actually, because people don't often talk about it. I think it's very important for the bar, as in the community of the bar, from the
Mm.
standpoint of being within the bar, that members of the bar um, do seek to develop positive relationships with each other. I mean, after all, it is all our workplace. The court is an odd example of a workplace because in a sense, it's not artificial in the sense that it's unreal, but it's very real, particularly for clients and indeed for practitioners and judges. But in fact, there's a heightened reality about court. But in a sense, but of course, it has its own rules, it has its own formalities, it has its own procedures in the literal sense of the word, and so people aren't in court with their guard down and relaxed, and you have to therefore adopt. You are, to that extent, to go back to say what I said earlier on, you are performing to that extent in court, and you have to do so in relation to your opponent. But none of that means that you're not in a workplace, and I think that there is an important responsibility that we have as barristers to other barristers to ensure that even in the formalized environment of a court, certain lines aren't crossed. You can argue a case robustly and still always respectfully and politely to your opponent. Same, by the way, should go for judges. And that applies all the more so, surely, outside of court, where you don't have the immediate pressure of being in court. It does place us under pressure, it does test us, and can make maintaining that relationship more difficult. When you're removed from that more immediate pressure, I think it is very important that the bar has that. Of course, one thing that barristers sometimes feel, entirely understandably, is a pressure from their clients to
Mm.
appear at all the times that, if you like, the client is a witness to it, which will be in court and occasionally outside of court. The barrister will feel a certain pressure from their client to be appearing and to be robust with opponents and challenging of opponents. And different barristers, no doubt informed by their different personalities, take different approaches to that. And that's fair enough. We're offering a service to clients, and part of the service we offer is to not just demonstrate the appearance of being tough, but where necessary to be tough to opponents. But you can do that in a polite and respectful way and maintaining the relationship with a fellow member of the bar, um, providing that everybody understands that that's what's going on. Um,
I think that that's a really important distinction to make. And I think, like you said, it's one that a lot of people talk about. I think we watch, TV shows and think that, inside and outside the court, every barrister that's opposite any other barrister, never get along and they, they sort of don't talk to each other. But of course, it's just like any other workplace. And ultimately they're your work colleagues in that sense. Even though, like you said, it might be a more artificial workplace than for most.
there can be a risk of it going the other way, in the sense that
Mm.
the client, um, as I just said, you might feel the pressure bearing down on you, from your client to appear to be rather more robust, so that the
Mm.
um, you don't want to appear too chummy with somebody that you're against. It's a difficult balance, and it depends a bit on the areas of law you do. I think it's
Mhm.
fair to say this public lawyers, judicial review lawyers, all the cases are important cases. Don't get me wrong, but quite a lot of the work that public lawyers do, not all of it, but quite a lot of it, perhaps isn't to be characterized as life or death work, or
Mhm.
work that necessarily has quite as immediate, direct, and serious an impact on an individual as some of the work does outside of the field of public law. I'm thinking particularly of where individuals or organizations are challenging some government policy or other. Very important matter. It's not necessarily the same as the immediate impact that somebody has where the case is an inquiry into how they died as an individual, or compensation for life-changing injuries, or divorce, or there are all sorts of cases, of course, that we do in court which have a very immediate, direct impacts on people. Not all public law is like that, and that can sometimes help with engendering an environment in court that doesn't need to be robust. That said, it does become robust from time to time for certain.
I think it's a skill that you sort of develop as you go along, and I think it's one that you perhaps understand more once you enter the profession.
Yeah.
On the point of public law, one of the I guess areas are, especially in a lot of the cases that you've done, they've attracted a lot of media attention. It's all over the papers. A lot of people do know about it and are sort of aware of what that might be. Also, might mean that it can be controversial at times.
Yeah.
With some of
Yeah.
the examples you gave earlier. How do you deal with that sort of media attention, ensure that when you are in court and when you're dealing with clients, that you deal with it in a professional way without necessarily being blindsided by what's been written in the news about it?
There can be a pressure in a certain type of case to make submissions, to address the court, to conduct yourself in a way that is media facing rather than judge facing.
Mm.
It may not be in your client's best interest, by the way, to be distracted by any of that.
Mm.
The judge is never going to want you to do anything other than assist the court as best you can. And if the judge thinks that you're playing to the media, as it were, rather than playing to them, that can be against your client's best interests, which it's firmly your duty to promote. Having said that, it is part of the job of a barrister, particularly in cases where um, media reporting on the issue has an impact on your client. It is part of your service to the client, and you're acting in the best interests of the client to ensure that the way that something is put across to a court um, is how you would wish it to be reported in the media. And after all, provided that the media are, as the courts will generally trust them to do, responsibly reporting court proceedings, the media is able to report court proceedings. Most court proceedings are public, and therefore, how you conduct yourself in court is something that you can expect may be reported. So, um, being sensationalist is unlikely to help your client before the court, but there is nothing improper in assuming you're still making the best argument, framing matters before the court in a way that you would be content, your client would be content for the media to report it. Not only is it not improper, it will be in your client's best interest to do that. The balance is between, as it were, playing to the media gallery and ensuring that you're assisting the court and discharging your important overriding duties to the court.
I think in that sense, it's even more important in public law because, like you said, you may not be dealing with life or death situations, but you are dealing with situations which can affect, the entirety of the country and can affect a lot of people. And it's one person bringing forward that case, but it's actually going to impact a lot more than that. And I think that, understanding that balance of the media and, of course, your role to not just the court, but to your client is a difficult one to strike. On that point, could you tell us a bit about one of the sort of most challenging cases that you think you've faced in your career so far, and why in particular it was really challenging for you?
Well, an example that I was thinking of giving a moment ago that goes to this point about media coverage and
Mm,
um, and profile is, for example, that the so-called black cab rapist case. This was a case
mm,
that was heard a few years ago now, where the man called who's what has been called John Warboys, also John Radford, known colloquially as the black cab rapist, a man who was convicted criminally of in the criminal courts of raping a number of women, um, uh, deploying altogether grisly and grotesque method of drugging the women under the pretext that he'd won some money when
mm,
they came into his cab, and offering them a glass of champagne or something similar to celebrate with him the winning of this money, which contained drugs. And which, after this, stupefied the women, enabled him to sexually assault them in most horrible ways. Um, the legal case that I was involved in wasn't his criminal trial, but was a subsequent judicial review that had been brought against a decision of my client, the parole board, whose job it is, as your listeners, viewers will know, to decide whether or not people should be released from prison at the end of what's called their minimum term or their tariff, so the time when legally they're allowed, consistently with a sentence of the court, to be released if they're no longer going to be a danger to the public. The decision of the parole board in his case to release him, and victims of war boys were aggrieved at this. There was a view that he had not conducted himself transparently and honestly before the parole board who made the decision to release him. And two victims of war boys very unusually, judicially reviewed the decision of the parole board to release him. I say very unusually because almost all, I think possibly every single previous judicial review of a parole board decision on release was a decision not to release someone by the prisoner. The challenge usually brought by the prisoner. This was a very unusual, I think, literally unprecedented example of a case where a victim was complaining about the decision to release him. And the reason it came to mind, Shrey, is because I remember that my client, the parole board, was very keen to get across to the court the enormous sympathy that it had for victims of war boys. And it was no part of the defence to the judicial review claim to adopt a position that was anything other than fully sympathetic on that ground. Nevertheless, it was
mm,
necessary for the parole board, if they're going to defend the case, to defend it. And we had to make a legal argument, and did make a legal argument, albeit that it wasn't accepted by the court, that as a matter of public law, the particular decision makers who sat on that parole board case hadn't made a mistake of law, which is what it was necessary for the claimants to establish. It wasn't a matter, it never is on judicial review, for the court deciding whether or not they would have released war boys. The legal issue on the judicial review was whether the parole board members had made a mistake of law in making their decision. So it's a good example, that case, I think, of where it's important for the client to position themselves in relation to the overall matter of war boys offending and the position of victims of war boys as a whole, to which, of course, it was thoroughly and in an unqualified way sympathetic. And on the other hand, having to do its job. And that was the way that we presented the case to the court. In the end, as a matter of interest, the divisional court decided that the decision should be quashed. It was unlawful because the parole board hadn't considered certain relevant information in the form of a civil law judgment, so not his criminal trial, but civil law proceedings that had also been taken against war boys by victims of him, that they hadn't properly considered the impact of what those civil proceedings found on what he told the parole board. So there was a question of inconsistency between what he told the parole board on the one hand and what appeared from those civil law proceedings, and the court said that it was an error for the parole board not to explore and seek to resolve that consistency. The matter was then reconsidered by a different parole board, and it was decided that he should remain in prison.
Thank you so much for such a detailed explanation. I think that
Sorry,
was
it was probably too detailed, but
no, no,
trying to
I think
bring
that
out the distinction between the making of the
yeah.
legal argument as
Hmm.
the firm duty of the advocate, and on the one
Hmm.
hand, ensuring that one is positioning one's client in a way that is correct in a
Yeah.
broader public facing way.
I think it's really important because I think that sometimes what the media can do is sensationalize certain decisions or certain things and actually not explore the nuance that is needed in, understanding that. And more likely than not, most people are, unlikely to go and then read the judgment and see what actually happened and the arguments that were presented. But I think it's really important to understand, both from the barrister and the, kind of the parole board and or the any institution's perspective on the reasoning why they were doing that, and you're not just kind of taking a part of the judgment that added to the story that was already being created in the media. I guess that brings us nicely on to talking a little bit about your podcast and what it sort of seeks to do. Could you, I think one of the first things that I came across was the tagline of, for law people and lay people and everything between. I really, really liked that. So could you talk to us a bit about why you decided to start the project and what the aims of the podcast are?
So thanks very much. First of all, I mean the central thing is, glad I've got at least one listener. So that the central aim of it is to explain the law to a wide audience, not just
Mm.
to develop legal discussion within the legal fraternity and using language that we comfortably use within the legal fraternity. And I do, by the way, think that the legal community has its own language. In a literal sense, it does. We use terms that aren't used outside of the law to describe things, but also in a broader cultural sense, we have our own language. In other words, we're comfortable in speaking to each other using certain language, and it can be exclusionary if you're not, if you like, a member of that community. It's the way we speak. It's not just literally the words we use sometimes. So part of the core of the idea of the podcast is to be mindful of that wider audience and to explain the law to everybody. That's the law people. Um, it's true that in order to enjoy the podcast, probably you need to have some level of interest in law, but I think lay people do for the most part. I mean, I found when I talk to people about cases and the work I do, most people don't glaze over. There are some notable exceptions, sure, but most people don't. They are quite interested in hearing about what the law is. And they are pleased to receive an explanation for it without somebody charging them for it, and also pleased to be able to think about and use law as a vehicle to think about wider questions, policy questions, moral questions, ethical questions, cultural, societal questions as to how we should interact. So that is the thing that we've tried to set up. We try to do it by ensuring as well that there is the real experience of an individual at the heart of each episode. And it's something I'm going to try and do more of in series 2, to put an individual experience, somebody who's been through an experience in relation to a particular area of the law, who will usually be a non-lawyer, speak to them, interview them, listen to their story, and then legally consider its implications, both in terms of explaining how the law would apply to their situation, but also thinking whether or not the law is fit for purpose, whether it should change or not.
I think you raised such an important point there because I feel like you said, there are terms that most people outside of the legal profession may not understand, but law is something that affects all of us, and
Yeah.
particularly the area that you practice in. Those decisions impact our everyday and our day-to-day lives, and so it's really key that we're able to understand those decisions, even if not every single legal argument made, but the overall decision and how that's happened. And I think some of the areas that you've explored, everything from AI to the most recent episode, I think are all current topics that people are talking about. So, how do you decide which topic to discuss in particular? And also, how do you decide which guest to bring on in order to do that most effectively?
Well, the topics are very much a case of just getting a sense from everybody, who I liaise with, but also much more broadly from the media, and a sense of what people out there would like to hear about. Sometimes the issues are narrower, sometimes the issues are broader. A narrower type issue would be, I did one on medical cannabis. So there's a specific issue there in relation to the treatment of very unwell children, for example, who have severe epilepsy, as to whether or not they should be able to access on the NHS medical cannabis in order to reduce the numbers of seizures that they're having. There's much wider debate that could be had there about how we access different types of drugs for different purposes and so on and so forth. There's a reasonably narrow kind of issue there. Something like AI and discrimination, however, is much broader because the reach of AI can go into all sorts of, already, of course, is all over all sorts of spheres of our lives, not just those who would employ us, but more broadly, public authorities and so on. Some are broader, some are narrower, but they're all ones that the common denominator is, a topic where there is some cultural, social, or ethical or moral dimension to what the law is about, rather than being something and that is contemporary, rather than being something where on, as it were, currently settled issues, which people aren't talking about. So in the second series, for example, I'm going to do one on protest. There's been a lot of issue over whether or not the law on protest goes too far, strikes the right balance between freedom of expression and other countervailing interests. I'm going to do one on asylum. The Rwanda policy of the government has, of course, been a major news story. I'm going to do something on school inspections. It's a terrible, sad case recently of the head teacher who unfortunately took her own life in the context of an Ofsted inspection. That sort of thing. It's intended to be reactive. We record them in series, series at a time. So we don't do them, the day, as it were, that a story breaks. There's more preparation that goes into it than that. And in terms of your second question about the guests we get on, what I try to do, and I suppose I've been fortunate through having gained a bit more experience in my career now, is to reach out to individuals who I know will be the top people on the lawyer side, who will be able to discuss it knowledgeably. We always try and get balance so far as we can in that respect on the lawyer panel. There are usually two on the lawyer panel. And then in terms of the person, the non-lawyer that I hear from and interview as to their own story in each episode, sometimes I will have a link, or I will have a link indirectly to somebody who I'm able to invite on. Sometimes I will invite them myself directly, even though I don't have any link. And sometimes the legal panelists are very useful in being able to suggest ideas for people because, of course, they have clients. And it's a very lawyerly thing to do. This is what we do, is we listen to people's stories. We listen to facts of situations that they've been in, and we have to then come up with a legal analysis of that situation. I hope that's a way that enables members of the general public, as well as the legal community, to engage in some of these topics, which need to be debated anyway, because they're contemporary, because they are matters that we need to be debating anyway at a moral, ethical level in any event.
Definitely. And I think that combination is really key of having people who are experts in that field from a legal perspective, but also having lay people so that, like you said, it's applicable to everyone and everyone can understand it, because these topics are being debated in the media, are being debated in households, in schools. And so understanding and having that balance, which sometimes can be missing, when you are just kind to put forward one view and not considering the other. And so having that balance, I think, is so key, regardless of what topic it is that is being discussed. From your perspective, what are your sort of aims with season 2 of the podcast, and what do you sort of hope to achieve in that second series?
Well, we're going to do a video record of the podcast, which will give a technical answer, but that is a difference. So the first season was just audio only. But what we're going to do in the second season is to have an audio version, and then we will trail certain clips of that on social media, which again I hope will help with engagement. We are going to continue broadly the same format as we did with series 1, but I do want to tweak it a bit in the way that I've mentioned, to give a bit more prominence to that personal story of individuals who are affected. We'll probably hear a little bit more from them than we did in series 1. You'll probably hear a slightly longer interview than you would in series one when we did a package of things that they were saying. You'll hear a slightly longer interview between me and them, perhaps a little bit earlier in each episode in series two than we did in series one. But otherwise, the focus is going to remain, Shreya, on seeking to explain, break down, de-jargon, if that's a verb, take the legalese out of our explanation of how the law operates, basically, in a particular area, and then to use all of that as a platform for considering whether or not the law should be changed. And if so, how should it be changed? And the law offers a great framework for that, because legal principles have a mechanics to them and have a shape to them, which moral or ethical arguments don't necessarily do. So you can approach a moral or ethical topic through the lens of law in a way that enables you to think about it still helpfully, but differently from how people are often used to debating them. I think that's something, again, that I feel members of the general public, even though they may not be lawyers, do engage in and are interested in.
Definitely, it sounds hugely exciting, and I can't look forward to listening to season two of the show as well. We tend to have a bit of a personal sort of growth and sort of tip section before we have our rapid fire. So we've spoken a lot about, public law, the work you do, and also I can clearly see the passion you have for it. So could you talk to us a bit about what sort of motivates you to come to work every day currently, and is that different to what it was when you started all those years ago at FTB?
Is it different? Is it different? It's a very good question. I can have a go. I can have a go at the daily motivation. I'm lucky. I do a wide variety of interesting stuff. I'm lucky in that, and I feel lucky in that. I feel that, as it were, I'm able to recognize that. And I like constantly to look out for the next challenge. I think that's the best answer I can give. I feel like I have an appetite to move on to the next thing. Not, I hope short-circuiting the thing that I'm currently on, but I feel an enthusiasm to find the next interesting topic. Policy, which is the general factual context of the legal cases that I do, is not only an ever-present topic, but you are constantly fed through the media, through engagement in politics, if you're interested in that. And I'm not party political myself, but I'm interested in politics and policy as part of the background to what I do, provides just a constant daily source of interest every day. If we looked on whichever news website you cared to do right now, we would see a number of things that have legal implications. And so there's a constant diet, and that, I suppose, keeps me going, because whether I like it or not, I'm fed it. And I think, oh, that's interesting. There could be something about that, or there could be something about that. And strategic litigation, which is something I do. In other words, litigation where, as you say, there's a wider impact than that which applies just to the actual parties to the dispute. If you get involved in that, you have to think creatively in that way, and that's part of what I do. That's the best answer I can give you on what motivates me day to day. I mean, I think I've probably had that broadly throughout my career, but I've enjoyed getting a bit more senior. Um, it does enable you as a barrister to. I enjoy working in teams. I now enjoy working increasingly with more junior barristers as part of my team. Occasionally, the work of the barrister can feel a little bit lonely, and that's alleviated to some extent if you're working as part of a team. People say the same thing about judging, by the way. And so that's something I've enjoyed increasingly as well, is working with slightly younger people as part of a team to develop the project.
That sounds incredible, and I think I can really see that journey that you've sort of gone on, starting all those years ago from FTB, and kind of going not just in kind of seniority, but also in the way that you work and in the way that you engage with it. And finally, if you had to give some advice to your 18-year-old self all those years ago starting at university, what do you think you would say to that 18-year-old Tom?
I think I would say you can't predict everything. You can't
Hmm.
know how everything is going to turn out. You literally can't. And if you think you can and you try and design it that way, you're going to be disappointed. Control the things go back to something I said near the start of this conversation. Control the things you can control. So reach for the stars if you have the ability to do, go for it. But at the same time, remember you can't control everything. Things will happen in your career and in your wider life, by the way, if we want a broader philosophical perspective, which you can't control. Um, and you need to be able to ride with that, to recognize that change will occur and to be comfortable with the fact of change, even uncontrollable change. If you can find a way to master that, you're probably on a journey to true peace of mind that almost none of us ever achieve.
Absolutely, and I think that's brought us nicely full circle from where we started, just like you said. So we always finish with a bit of rapid fire, just to end on a slightly kind of cheery note and get to know
Sure.
our guests a
Yeah.
little bit more as well. So yours is in this season we've kind of tried to kind of tried to personalize it according to the guests that we've had. So your first question is, what has been your fiercest cross-examination so far?
This is now, do you mean the podcast cross-examination? Or do you mean a cross-examination in court? Or
Perhaps it
can
could
I
be both. It
answer it
could be
either
both.
way? Well, in court, you are taught at bar school that there's this expression that many of your listeners will have heard, I'm sure, which is that cross-examining isn't examining crossly. If the examiner lets fierceness, I suppose, or anger or crossness enter into the nature of the questions they ask or the style with which they ask the question, they're probably not doing their job properly. Whereas a good cross-examination can actually be will actually be very calm and forensic,
Mm.
even quiet and subtle and so on and so forth. So I'm inclined to say if I've ever done a fierce cross-examination in practice, I haven't done it very well. But I did a little bit less cross-examination now in tribunals and courts. But I suppose some of the toughest that I did was in the employment tribunals when I did a bit more employment law,
Mm.
just done public and human rightsy stuff. I used to do quite a lot of employment tribunals, and you'd have situations where perhaps you were cross-examining somebody who had fired your client. I remember doing a case for a mechanic once who had been dismissed in circumstances where it was said that he hadn't properly fixed a wheel to an HGV vehicle. And his defense, so that the case I had to run on behalf of this client mechanic, was that there was an act of sabotage. This is a real story. There was an act of sabotage by the employer. So he hadn't touched this wheel, he was nowhere near it. And somebody else had sabotaged it, and he'd been stitched up and dismissed for the act of somebody else who didn't like him. Now, this was an ambitious argument to run because you won't be surprised to hear there wasn't very much evidence of sabotage. But unbelievably, and through a series of events that I haven't got time to describe, we managed to win the case, and the judge at Ashford Employment Tribunal was persuaded that at the very least it might have been a sabotage, and therefore there was an unfair process that was followed in relation to his dismissal. That, I think, was a fairly fierce cross-examination, probably illegitimately fierce cross-examination.
Yeah. A fierce and a rather creative one, I think. We're gonna have to get you on next time to talk in detail about that case. The next question is, how would you pitch the job of being a barrister to an undecided law student?
Um, there are a number of strands. I mean, the truth is there are a number of strands. If I could give, if there was one thing that sort of defined it, what is it? I mean, it's a capacity for intense hard work. There's no
Mm.
getting around that. I don't think any barristers who do their job well can avoid intense hard work.
Mhm.
But beyond that, um, golden seam, it's very varied, like we were saying earlier. And
Mm.
don't approach it, I would say, with preconceptions as to what it's necessarily going to be like. You're also self-employed most of the time, most barristers are self-employed, not all actually, but most are self-employed. And those who are, if you choose to go down that path, that gives you a real opportunity, particularly to get more senior, to make the job work for you rather
Mhm.
than the other way round. You can you can locate it within the life that you want to lead rather than letting it dominate your life.
Definitely. And on that note, then, talking about, work like for us, what does an ideal weekend in your life look like? Hopefully one that's relaxed.
No work, I wish there were many weekends where I don't have to think about work at all. I'm afraid that the majority of my weekends are not in that category. I have to think to some extent or do to some extent work, although not so many in recent times where I've had to work all weekend. I'm pleased to say. Perhaps I'm finding a better work-life balance as I get a bit older. But an ideal weekend will be the sort of weekend that I'm about to have with my partner starting tomorrow, Shreya, where we're driving out to, it so happens to be an east part of the beautiful Kent countryside with our dog. We're going to do some walking. We're probably going to go to the pub more than once, and we're going to try and forget about the very busy professional lives that we lead in the course of doing that.
That sounds amazing. The next one is, what is the best advice that you've ever received?
The best advice I've ever received would be from my father, who in the early part of my career, where I remember coming home from a very intense day in court and questioning whether or not I wanted to carry on doing the job, such was the intensity of the experience. And this is very common to a number of barristers who I know suffer from it, feeling that I hadn't perfected everything, that I haven't got everything quite right, that it was okay what I'd done, but it wasn't good enough. My father said to me, "You can only do your reasonable best." What a trite and obvious thing to say, you might think, and it is, but it is something we forget and fail to live by all the time. You can only do it. Many barristers tend towards being perfectionists. Many lawyers tend towards being perfectionists because you're constantly trying to craft an argument, a presentation of something, the way something comes across. It can always be tinkered with and improved, but you can only do your reasonable best. And if you can find a way to live with that,
Mm.
you'll manage to achieve a happiness that, or a level of happiness that otherwise you will struggle to attain, because otherwise you will never be performing at the level that you want.
Definitely. And final question, if you weren't a lawyer, or perhaps, that door was closed, what alternative career path do you think you'd have gone
I was very close to becoming an academic, believe it or not. During
down?
that year that I mentioned at the start of our conversation, where I think I probably decided that I wanted to have a go at being a barrister, my year abroad in Madrid. I reckoned in the year, but if you'd spoken to me the year before that, so my second year at university, I think I was about 80% persuaded that I wanted to become an academic. Very nerdily, I enjoyed a lot doing the sort of literary criticism kind of work that I mostly did as an undergraduate. My paternal granddad was actually a professor of English. He was an academic, and in the time he'd been, I think he died in 1996, but in the time he'd been alive, I got to know him pretty well. I was pretty close to him. I developed a love of the sort of life that he had and the lifestyle that he led. So I think I would have done that. I decided against that because I just thought there wasn't enough interaction with um, uh, real life situations. I don't, of
Mm.
course, mean that disparagingly to those who do academic subjects who will no doubt regard their professional lives as only too real, with all the rigors of university life and all the rest of it. But I think that I wanted to do something where I would feel that I'm more directly helped in an immediate way, as it were, a series of individuals with problems that they encounter. And that is fundamentally what most lawyers do. But academic would be one, and maybe teacher would be another. There's probably a didactic side to me. As well as a load of show-off actors, there's also a number of teachers in our family, which may also be a related thing. I had a biology teacher, an English teacher, and a PE teacher, I think, in recent generations of the family. So there's something about standing up and trying to explain things, and that's probably lurking there somewhere.
Yeah, and I think you're teaching wonderfully through your podcast. And today, I think you've taught us a lot. So I think you're definitely doing that whilst being, of course, a leading barrister yourself. So on that note, Tom, thank you so much for coming on the podcast today. It was a real pleasure to speak to you, and it had been on my bucket list for a really long time. So I've ticked something off, and I hope that a lot of people are going to enjoy our
Well,
conversation today.
well, it was a great pleasure to have the invitation, Shreya, and to talk to you. Thank you very much.
And on that note, thank you so much for listening to this episode, and a massive shout out to Tom for taking the time to come on the podcast and be so gracious with his time. I genuinely continue to be in awe of guests like Tom who are willing to give their time to come on platforms such as this one and dedicate their time to it, despite their packed schedules. And it's something that I never can truly take for granted. I want to thank all the listeners of this podcast and the CML community in general, because I have been given the opportunity to speak to such fantastic guests only because of all of you, and I thoroughly couldn't be more grateful to all of you for helping me do that. As always, please do send your feedback on commercemeetslaw@gmail.com. You can also DM me on Instagram at commercemeetslaw. We also have a YouTube channel for all of our video podcasts and extra CML content, so do check it out if you haven't done so already. For now, take care, goodbye, and I shall see you for part three and the final part of this series.